to Crime in Court. My name is Heather. This is the second part of the defense's second motion to disqualify Judge Gull. So we are obviously talking about the case of Indiana versus Richard Allen in the Delphi case. And yeah, so this is part two. So if you missed part one, the link will be in the description below. So you can go there and then come back to part two. We're gonna we're gonna pick up right where we left off last time. So we're about halfway done. So got maybe another hour left or so to get through this. So but it's quite interesting. It doesn't feel like it takes that long. So let me shrink myself. That would help so you guys can see. I'm gonna actually shrink that a little bit too so I don't get in the way. All right. So here we're going to continue off where we left off, and that is we were at 65, so we're going to pick up at 66. So please hit that like button and let's dive in. All right, so Judge Gull wrongly blamed the defense for ex parte filings which were inadvertently directed to the prosecutor. Yeah, so we talked about this in the last video. Ex parte filings mean that only one party should see it. So it's if I am an attorney and I'm filing something ex parte, that means it's just for me and the judge to see, not the other lawyer in this case on whatever other side. So if I'm filing it and I'm on the state or the defense, it doesn't matter what side I'm on, the other side can't see it. So there was an instance in the Delphi case where Richard Allen's team filed some things ex parte, and wouldn't you know, Nick McClellan files something, and you're reading along in this motion, and he quotes it. He quotes an ex parte filing from the defense, a filing that he shouldn't have laid his eyes on. So how did he get it? Did the court give it to him? Did the court inadvertently direct it to him? Is that what it says here? So what's the story there? Let's see if we get any more context. So number 66, the defense learned from a prosecution filing that the prosecution had somehow received Mr. Allen's ex parte documents that were not to be viewed by the prosecutor. 67, upon inspecting how this happened, the defense determined that Judge Gull's staff or the Carroll County clerk errantly misdirected these documents to the prosecutor. And we've had issues in the past in this case where things have not been filed properly, and it almost looks as though Judge Gull might have been trying to hide some certain things that she didn't want in or whatnot. But then she blamed it on the clerk. So, which is it? And now there's ex parte filings that shouldn't have been given to the prosecutor that were. So, neither of those things could have been the prosecution's fault. Number 68. When defense counsel's staff reached out to Judge Gull's staff to determine why and how multiple ex parte motions had been sent to the prosecutor, Judge Gull, without investigating the matter, fired off an email to the defense disparaging its staff and placing the blame on the defense. So she takes no no accountability for any of it, and she instead blames the defense. Somehow they didn't do it right. Okay. 69. Having been accused by Judge Gull of making the mistake, the defense staff member who filed the ex parte motions then reached out to Docs Pop to make sure, that must be whatever they use, to make sure that she was filing the ex parte motion correctly. It was determined that the defense was filing the motion correctly. The entity responsible for sending the ex parte documents to the prosecution, therefore, was either Judge Gull's staff or the Carroll County clerk. I'm thinking it was Judge Gull herself. I really do. Like, I wouldn't even put it past her at this point. I have no respect for her. I don't care that she's a judge and she wears a robe. I think she shouldn't. I think she should take it off permanently. I don't think she's fit to judge. Number 70. Attorney Rosie then reached out to the Carroll County clerk who maintained that she had correctly handled the ex parte documents. So, that only leaves one other party. And it wasn't the Carroll County clerk, and it wasn't a mistake on our part. So it had to have been someone in Judge Gull's office. Process of elimination. Number 71. The defense is in possession of screenshots which prove that the defense counsel's staff filed the ex parte matter confidentially, and that proves that the defense staff provided service only to attorneys Rosie and Baldwin and not McClellan or any other person. So, just more verification that it didn't go to them from the defense. This is the proof that the defense staff followed the rules for filing ex parte motions. The defense did not send out the ex parte motion to McClelland in spite of Gull's quick accusation. Number 72. Judge Gull failed to investigate how such a significant error could have been made to avoid misdirected ex parte filings in the future, but rather simply blamed it on the defense. Like, this is I don't know anything about law. I'm not, I'm not a paralegal. I don't have a law degree, but I do have some understanding that there has to be some kind of process put in place. And if you have these ex parte filings, there's a process in which things are done to avoid things like this, to avoid Nick McClellan getting ex parte. Like, it even said ex parte in the title, yet he still chose to somehow. Did he not know what ex parte meant? I don't know. I mean, he's been a lawyer for a while. These should be basic knowledge things for anyone that's been in this profession for any number of years. I mean, they should know how to file these things. It should be a no-brainer. It shouldn't be um, there shouldn't be a question as to how it got leaked. These are simple proceedings, and not even that it got leaked, but just the fact like these are simple proceedings in the way you file your motions that are done on a daily basis in courts all over the world, and yet somehow it got messed up here. All right. Anyways, 73. Judge Gull's reaction in blaming the defense for the ex parte leak of information when the leak appears likely to have emanated from Judge Gull's own staff shows a rational inference of bias. Not only that, I think I would go as far, like I said, to say that Judge Gull herself handed it over to McClellan. Accusations of, and I don't have any proof on that. That's just me speculating, just based on how she has been in the past. So it's either someone who answers her email or someone who in her office that has access to everything that comes in. I'm sure she has some kind of staff member that does clerical tasks. Anyways, accusations of violating rules on access to court records. Number 74. Due to the way Judge Gull maintained the records on this case, attorneys Margaret Smith and Kara Weinecke entered their appearances and filed a petition for writ of mandamus and prohibition, original action, whatever that means. I don't know. Not a lawyer. Um, 75. Following Smith and Weinecke's original action for writ of mandamus, Judge Gull hired a lawyer and then was forced to cure most of the issues that Smith and Weinecke identified prior to the hearing in the Indiana Supreme Court. So that was because of the way she was mishandling the records of the case, I think. And these two came in um, basically to identify, I don't know, Smith and Weinecke's original action for mandamus, they hired a lawyer, or Gull hired a lawyer and was forced to cure most of the issues. So they probably identified a bunch of the issues that were going on with the reporting system and forcing her hand to make sure that changes were made to cure it. All right, so number 76. In other words, Judge Gull and her attorneys recognized that she had errantly violated the rules on access to records and then cured those errors. So she fixed them quickly. 77, well, I don't know about quickly, but she fixed them once this whole issue came up regarding the who had what access to what. Number 77, calling the defense incompetent, grossly negligent, and sloppy while ignoring the fact that both the court and prosecution have been accused by others of behavior that might or would be considered incompetent, grossly negligent, or sloppy, provides a rational inference of bias. Defense motions are treated differently than those of the prosecution. Number 78. This filing is really nicely organized. Like this is exactly how I would want to do it. Like here's the charge or the accusation I'm saying, and then here's all the reasons why. It's very nicely organized. Whoever wrote this. All right, so 78, while at least 5 outstanding defense motions were pending related to the merits of the case, all which needed to be ruled on as soon as possible for purposes of trial preparation for the defense, Judge Gull chose to not issue orders or set hearings on any of those motions. Instead, Judge Gull chose to spend valuable court time setting a half-day hearing on the prosecution's motion for contempt. The prosecution's motion for contempt did not address the merits of the homicide allegations against Richard Allen, nor was the contempt motion a time-sensitive matter. Agreed. 79. There is no reason that the contempt hearing could have not taken place after Mr. Allen's trial. Number 80. The prosecutor filed his motion for contempt against the defense on January 29th, 3 days later, February 1st, Judge Gull issued an order setting the matter for hearing. So 3 days, she responds. The defense has never received such a quick setting on any of its motions. Usually they're waiting weeks. Number 81, even at the most, several outstanding motions have yet to be ruled on. Like, we've asked you 4 times now for a Frank's hearing. And she's still just ignoring that fact that, there's this whole oldness thing that we got to talk about, the big elephant in the room that she doesn't want to address. 82. For example, the record shows that on more recent pleadings filed by the parties, Judge Gull quickly prioritized the prosecution's request for contempt over the following defense motions. A motion to suppress confessions. The defense filed this motion on April 11th, 2024, but it was ignored by the court until the recent May 7th, 2024 hearing. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt while setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defense's motion for suppression of the confessions for nearly a full month and then only did so at a hearing. B. Motions to suppress the accused's second statement. The defense filed this motion on April 15th, but it was ignored by the court until the recent May 7th hearing. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defense's motion for suppression of the accused's second statement for over 3 weeks. My dog having a nightmare. I think that's my dog having a nightmare. Yeah, his paws are going crazy. I thought it was hail on the house. All right, so again, it took Judge Gull 3 days, and she has not ruled on the defense's, or it took her a month. She didn't even acknowledge the defense's motion for suppression of the second statement for over 3 weeks and then only did so at the hearing. I see where all these are going. C. Motion to compel and for sanctions. The defense filed this motion on April 23rd, but it was ignored by the court until the recent May 7th hearing. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt, while Judge Gull failed to even acknowledge the defense motion to compel and request for sanctions for over 2 weeks and then only did so at a hearing. Abby, lay down. She's like circled 10 times at least. She did not want to lay down. All right, now she's quiet. Sorry. D. Motions for Franks. 3. The defense filed this motion on March 13th. Judge Gull has ignored this defense filing now for 62 days through May 14th, 2024. So it's been even longer now because the clock is still ticking. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later. While Judge Gull failed to even acknowledge the defense's third Frank's motion, even up until the time of this filing. E. Ruling on the first Frank's motion. Additionally, while it took Judge Gull over 4 months to rule on the first Frank's motion, denied without hearing, it only took Judge Gull 43 days to issue an order on the prosecution's request to find the defense attorneys in contempt following a half day of testimony. Wow. So 43 days, and she turns around with an order from the contempt, whereas we're still sitting here 4 months later on the first motion, or it took 4 months, sorry, for the first Frank's motion to be addressed. And then that was denied without hearing. We've had a second and third Franks now, which we're still waiting for, and nothing. 83. The prosecution's contempt motion is not relevant to the merits of this case, while the defense's various motions described above are relevant to the merits of the case. Yet Judge Gull acted on the prosecution's motion within 3 days while ignoring the defense motion for weeks. Judge Gull ignored other older defense pleadings sometimes for months before ruling, which also can play a big part if a judge is not ruling on your motions. It can play a huge part in delaying the trial. If you set a speedy trial date and you've got all these pretrial motions and you're not getting an answer from the judge, that delays you from being able to do your preparation for the trial. So she's taking time away from them by ignoring their pleading or their filings. It's unreal, man. This is so like underhanded and dirty that Judge Gull could be doing this, but I definitely think she's doing it intentionally. There's no doubt in my mind that she's got this intentional bias against them and she's doing this on purpose. Many defense motions have resulted in Judge Gull issuing an order stating these 3 words, denied without hearing. Since their reinstatement alone, Judge Gull has denied defense motions without hearing a total of 8 times, including denying motions to compel discovery, which Mr. Allen needs to prepare his defense. 85. Judge Gull's quick treatment of the prosecution's motion on matters ancillary to the innocence or guilt of Richard Allen versus Judge Gull's treatment of defense motions that are related to the merits of the case provides a rational inference of bias for Judge Gull's bias for the prosecution and against the defense. Number 86. Certainly, it appears that Judge Gull used the prosecution's motion for contempt as a vehicle to malign the defense while simultaneously ignoring matters raised by the defense that would malign the prosecution for its handling of discovery. This provides a rational inference of bias against the defense. Judge Gull ignored the defense's request to set aside 2 weeks to present Mr. Allen's defense while refusing to set any time limits on the prosecution. Now, that is dirty and underhanded and just wrong. Number 87, on or about October 4th, 2023, Mr. Allen's counsel notified the court that they would need approximately 2 weeks to present his defense. Number 88, in the aforementioned April 28th, 2024, Sunday morning email, Judge Gull sua sponte issued a stern message in the email. I think that just means like on her own accord, doesn't it? I don't know. Let's look that up. We've looked it up before on my channel and I've forgotten. I have forgotten. It's always good for a reminder. Sua sponte, meaning, yes, of one's own accord, voluntarily. So that was, I did have the correct definition in my mind. So, where were we? So Judge Gull, out of nowhere, on her own accord, she just issues this stern message in an email indicating that the trial would end on May 31st, 2024, not more or less. So she's like cutting them off at the knees again. She just keeps doing this. Like, we are not allowing more time and you won't get any time. But she also wouldn't allow any kind of time limits on the prosecution. So they could literally take up the full, like, 3 weeks she had allotted for it, and the defense would have no time to present a defense. And she thinks that's fair. I don't. And a lot of judges or a lot of lawyers that I listen to on YouTube say it's not usually common for an end date for trial. It's like you go until you go, like you go until you present your evidence. I mean, it's not unlimited time, obviously, and the court doesn't want you to waste time, but if you're presenting things that matter, then you should be allowed to keep going until you've presented your case. So for her to set a time limit on this is bogus. All right, so 89. Before issuing her order on the days allotted for trial, Judge Gull failed to reach out to the parties in order to determine how many witnesses were expected to testify, the expected length of their testimony, how many videos were expected to be played, and the length of those videos, and most importantly, how long each side expected their case to last based upon the evidence that they expected to present. So usually you do this in your pretrial motions, hearings, and things. You arrange prior to anything is scheduled. You in a hearing with all sides being heard and the judge, her calendar up for debate. We're talking about, this is how much time we need. This is how many witnesses we have. This is how many exhibits we plan to show. All of that stuff that is done to help in the logistics of putting the trial on. Those need to be discussed in their pretrial hearing. So why she didn't have a pretrial hearing and take it upon, take it under advisement, under, what everybody needs. You need to try to assess everybody's needs and help accommodate. You're not the ruler of time saying like, well, prosecution has unlimited time and the defense has none. That's not how it should be. And that shows bias. Anyways, um, so 89, before issuing her order on the days allotted for trial, Judge Gull failed to reach out to the parties in order to determine how many witnesses they were supposed to have, expected testimony, length of videos, all that. And most importantly, how long each side expected their case to last. So each side will say, in their pretrial hearing, I need 3 weeks to put on my case. I need 2 weeks to put on my defense. Usually the prosecution they have the burden, so they usually take a little bit longer. Plus, a lot of information comes out in their direct and cross examination that you don't need to do in the defense's case. So usually, the prosecution might get a little more time, but not a ton. It shouldn't be they get all the time and you get none. That's not how our justice system is supposed to be, and that's she knows that, and it's so disgusting what she's doing. All right, number 90. Between all defense counsel with a combined 70 years of experience, because now they got one more on their team, the Jennifer Auger, not one time have they been told that a trial would absolutely end on a certain day and not go any longer. So that's what I was saying is that other YouTube creators were saying they've never been told this. They've never had time limits like this before. So what kind of crap is Judge Gull playing? She totally forced their hand in having to waive the speedy trial, which is probably best knowing now that they keep getting more data dumps from the prosecution, so at least they have a little more time to go through all the data, maybe. All right. Number 91, Judge Gull's inflexibility only impacts the defense as the prosecution presents its case in chief first and therefore likely would have enough time to put it on its case, leaving the defense with little or no time to put it on its case in chief. Number 92, Richard Allen possessed 92. We went from 18 from their first request to recuse Judge Gull, but now we're already on 92, 93. So when the defense asked Judge Gull, oh no, I missed 92. We were on 92. My screen, hold on. Okay. 92. When Richard Allen possesses constitutional rights to the compulsory process of having witnesses testify on his behalf and to confront witnesses pursuant to the Sixth Amendment of the Constitution of the United States, as well as a right to present a complete defense pursuant to the 14th Amendment. Number 93. When the defense asked Judge Gull at the May 7th, 2024 hearing if the state of Indiana would be forced to abide by same time constraints as the defense, Judge Gull would not commit to such a requirement of the prosecution, showing once again, her bias. Number 94, out of fear that the prosecution would run out the clock and leave the defense with minimal time to present its case, Judge Gull forced the defense to accept her remedy, a continuance of a speedy trial. Of course, she forced their hand at it. Number 95, because of Judge Gull's refusal to guarantee the defense the same amount of time for trial as the prosecution, Richard Allen was, for all intents and purposes, denied his right to a speedy trial. For sure. Number 96, all the above circumstances create a rational inference of bias against the defense and in favor of the prosecution. Judge Gull engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gull may have to rule on how the extrajudicial activities of a key state's witness will impact the admissibility of Richard Allen's purported confessions. Interesting. So, because I just want to let me read that again. I want to digest it a little more. So, Judge Gull engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gull may have to rule on how the extrajudicial activities of key state's witnesses will impact the admissibility of Richard Allen's purported confessions. Is she? I mean, her extrajudicial activities, what, like I said, I think she's part of this brotherhood or gang or whatever the heck it is, the Odinists. I think, um, I think they're everywhere. I think they've infiltrated government and the like. So I don't know, trying to protect their own. I don't know. It almost seems like that could be. I know that's not exactly what they're saying, but it almost seems like her extrajudicial activities raise concern. And then we've got the concern about the state's witnesses and how admissible their their testimony is going to be when they might be Odinists themselves. So that's you see that like the extrajudicial connection I was getting, like, oh, maybe because she's an Odinist and the key witnesses are Odinists too, and you don't want that admissible if you're trying to get the confession out. I don't know. I hope you know what I'm saying. All right, Judge Gull was appointed to preside over this case on November 4th, 2022. Since being appointed as special judge, the case has become one of the highest profile cases in recent memory, even receiving worldwide attention. The victims of the homicide are Abby Williams and Libby German. 100. On July 9th, 2023, more than 8 months after being appointed to the case, Judge Gull chose to comment on the post concerning oh yeah, here's the thing. On a post concerning a softball tournament at the Abby and Libby Memorial Park. So there is an Abby and Libby Memorial Park near town or in this, in the Delphi area. And there was a softball tournament going on. This is a social media post. The post upon which Judge Gull was commenting stated what an honor it was for the girls to play in the Abby and Libby Memorial Tournament. What a greater honor it was that Abby and Libby's grandparents presented our girls with their championship finalist rings. I didn't know there was that second part about the grandparents presenting the finalist rings, but I've heard about this before, and the grandparent or Judge Gull commenting on congratulations to the girls or whatever. What an honor it was for the girls to play. Oh, and she wrote congratulations. Yeah, the post upon which Judge Gull was commenting. Oh. So the text um in the social media post itself said what an honor it was for the girls to play in the Abby and Libby, blah, 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 all that. And then Judge Gull commented on that post and said, congratulations. Sorry, I was a little bit confused there, the way that was worded. But yeah, so she commented congratulations on this social media post that was out there for all the public to see. And I think that shows a little bit of bias if she's ruling on the case. She should not have been making any kind of extrajudicial statements. This is one of those extrajudicial statements that she shouldn't have been making. All right, 102. While seemingly innocuous, Judge Gull's choice to comment on a post involving a softball tournament celebrating the lives of the victims of the crimes in which Judge Gull is the presiding judge was inappropriate. Very inappropriate. Very unethical, I would even say. Certainly, when factoring in the other issues raised in the first motion to have Judge Gull disqualified, as well as the issues raised in the second motion to disqualify, Judge Gull's comments were even more inappropriate, providing an appearance of bias against Richard Allen and in favor of the state of Indiana, who is prosecuting the accused unaliver of the victims who are identified in the post. So very, very inappropriate for her to have been posting on that. Certainly when she was and when she's been asked to disqualify herself. Sorry, I gotta readjust my hips; they're hurting. Um, yeah. Sorry, moving on. Next, the defense believes that Judge Gull's choice to comment on social media, as detailed herein, on its face supports a rational inference of bias as well as an appearance of bias. Number 105, however, newly discovery evidence, newly newly discovered evidence adds another layer of conflict and bias to Judge Gull's post. On May 6th, 2024, the state of Indiana filed its formal request for a pretrial ruling on admissibility. When said request Within said request, the state referenced Dr. Monica Walla as being a psychologist providing services to offenders at Westville Correctional Facility, one of those inmates being Richard Allen. Subsequent to the filing of said pleading, members of the public began to discover evidence that Dr. Walla had joined and participated in social media forums, outlets, etc., involving the Delphi homicides. Naturally, these facts were reported to the defense throughout various means. Number 107. It is also true that the defense deposed Dr. Walla on Wednesday, May 8th. So this is recent. Like they literally just found this out and they're doing stuff about it. So they went and they deposed her at the law offices of Hillis, Rosie, and Dean. The deposition was not completed due to timing constraints and will likely be reset in early June, at which time the defense expects the deposition to conclude. 108. The defense was unaware of the apparent social media activities of Dr. Walla at the time of the deposition, and therefore the matter was not addressed. It wasn't until shortly after the deposition concluded that these issues were brought to the attention of Attorney Rosie, who conducted the deposition. Since May 8th, 2024, the defense has become aware of information that suggests that Dr. Walla did in fact engage in social media activities related to the Delphi homicides. The defense is not in a position to determine the extent and nature of said activities at this juncture without conducting further discovery. However, the defense is aware that the online personality purporting to be Monica Walla, including a picture of Dr. Walla, appears to have been deleted, removed, and or wiped clean from any online presence related to the Delphi homicides. Huh. So, as of recently, she just went and deleted herself from all of these chat groups and forums and things. This appears to have been done in the hours following the deposition referenced above. Oh, okay. Number 109. Again, this court is faced with a conundrum. The judge's decision to publicly comment on matters involving the homicide of the two girls is evidence that Judge Gull does not find it inappropriate to engage in such communications about a pending case. How then can Judge Gull be impartial in making any determinations on the defense's motion to suppress or state's request for a pretrial ruling on admissibility of communications between Richard Allen and his state appointed psychologist? If this court were to find that Dr. Walla's alleged acts were inappropriate, then by extension the same could be true about Judge Gull's acts. Interesting way to look at it. 110. As the purported confessions loom as potentially the most powerful evidence against Richard Allen, any appearance of bias or conflict that exists for Judge Gull as she makes determinations of the legal impact of this witness's social media activity on those purported confessions provide a rational inference of bias. 111. Additionally, even when Judge Gull rules against the defense and does not suppress the purported confessions, Judge Gull will likely face a second legal argument, the admissibility of any social media postings of this witness that involve the Delphi homicide in order to attack the witness's credibility. Number 112, should the prosecutor object, claiming that the witness's social media comments on the Delphi homicide are inadmissible, Judge Gull will once again find herself in a conflicted position due to her own social media comments concerning a post involving the victims of the homicides. Interesting twist. I like it. I like it. I like it. So Judge Gull's starting position apparently is that it was appropriate for her, Judge Gull, to choose to comment on a social media post concerning the victim's softball tournament. Therefore, it would be more likely that Judge Gull's starting position will also be that this Dr. Wallace social media posts activity are similarly appropriate, and neither one are. Number 115, with this starting position, the defense will face a heightened burden in arguing for the inadmissibility of the Dr. Wallace social media posts and activity. This additional hurdle, created at least in part by the court's inappropriate comments on social media, creates an inference of bias or prejudice against Richard Allen. Disqualification/recusal is the appropriate actions in terms of remedying this prejudice. And we're not done, folks. But if you thought we were done because there's just not any more that could be on this page, you're wrong. We're continuing on. Judge Gull has impaired Richard Allen's ability to defend himself by denying his reasonable requests for expert and administrative staff funding. 116. In 2023, the defense tendered bills for matters related to their defense of Richard Allen totaling over $38,000. Judge Gull has not authorized payments of those bills as of the date of this filing, and that is BS because that comes often out of the lawyer's own pockets then in order to pay for that. Usually they do get reimbursed by the courts if they're a public defender. It's crazy that the state has all the power, all the resources, all the law enforcement, everything on their side. And they can't give Richard Allen and his team some funds to perform basic things within. My boyfriend's home. And the dogs go running. Sorry. Okay. So they can't even perform like basic tasks that you do for, trial, like hire experts and use those experts to refute the charges for your client. And that's a normal thing that you do for as a public defender. And you would normally get that money back returned. I mean, you might have limitations, and the court might say, um, you're only allowed this much or whatever. But in the end, if you need that funding, oftentimes it does get approved. Why she's denying it, we don't know. Number 117, defense counsel has been forced to advance those expenses out of their own pockets. See, that's not right. 118, for example, the defense has paid $26,000 for the work its investigator performed in the spring, summer, and fall of 2023. When Judge Gull was not satisfied with the format of the investigator's bill, the defense tendered a new bill to meet the court's expectations. Because the investigator deserved to be paid for the work he performed, the defense paid the investigator out of its own law firm account. Wow. This is going to the Supreme Court, I hope. And I am so glad that it's public and everybody knows what Judge Gull is up to now. 119. After trying to rectify the issues Judge Gull had with the bill's format, Judge Gull has failed to order the payment of such expenses associated with the defense's private investigator. Number 120, the defense has sent multiple requests to Judge Gull and her staff seeking input as to why this bill has not been paid. Judge Gull has not responded to those requests. She just thinks that she's above replying to her email, I guess, when it comes to these guys. Number 127, the lack of response to these requests for payment creates a rational inference of bias. 128. Also, while the prosecution has unlimited access to funds and law enforcement experts, Judge Gull initially denied the defense request for expert funds for certain experts needed for the defense of Richard Allen. Only after the defense filed requests for reconsideration and apparent public outcry did Judge Gull change her mind and provide the defense funds for these experts? The refusal to initially provide funds to the defense for experts provides a rational inference of bias. Evidence that evidence that public confidence in Judge Gull has eroded due to continued improper conduct and conduct that creates the appearance of impropriety. Number 129, evidence of the erosion of the public's confidence in Judge Gull can be shown through letters that Judge Gull has received, as well as letters that the Indiana Supreme Court has received, as well as memes and other social media content that can be easily located on the internet. She's a running joke now because she doesn't know how to judge. A judge who doesn't judge. All right, so 130, find attached 14 letters and emails that members of the public have taken the time to draft and then sent either directly to Judge Gull or to the Indiana Supreme Court. These letters and emails provide evidence that the public perception of Judge Gull's ability to be fair and impartial has eroded. Yikes. Number 131. Multiple people paying attention to this case believe that an inference of bias and prejudice against the defense exists to such a degree that they took the time to alert this court and the Indiana Supreme Court to what they are observing. So this footnote number 6. On March 28th, Paige Moore wrote Judge Gull, among other things, saying Mr. Allen was denied funds for expert witnesses even though Americans are guaranteed a fair trial. Experts are needed for forced confessions and bullet markings. On April 1st, Oscar Lopez wrote to Judge Gull saying, among other things, I have serious doubts that you, the judge presiding over the case, is capable of being a fair and impartial judge in the case. On March 29th, Eliza Trick wrote to Judge Gull, among other things, you are the most biased judge I've ever seen, and you ought to be ashamed of yourself. This is not a fair trial. On March 27th, LGW wrote Judge Gull, among other things, it appears that the defense is being prohibited from being able to defend their client. On March 28th, Stephanie Cope wrote Judge Gull, among other things, the following. Sorry, I don't know what my dog's barking at. All right, so LG wrote Judge Gull, among other things, it appears that the defense is being prohibited from being able to defend their client. On March 28th, Stephanie Cope wrote Judge Gull, among many other things, the following. I have watched every phase this case has gone through. Like many others, it's shocking and disturbing seeing Mr. Allen and how his public defenders treated so unjust. I can't understand the lack of self-awareness you have concerning your own biased feelings. March 29th, Hope Douglas wrote Judge Gull the following. In my opinion, it is clear, as an outsider looking at this case, that you have presented your rulings as biased and almost always pro-prosecution. So that was the footnote, and that's just a sampling of some of the letters that Judge Gull has received. We've read other letters on this channel as well, and there were just some recent letters that came out. All right, so the perspective of common everyday citizens, i.e., objectively reasonable people, who have taken the time to voice their concerns about the apparent bias they are witnessing should not be overlooked. Judge Gull has refused to order the state to comply with discovery rules to the detriment of Richard Allen. 132, the Indiana Code of Judicial Conduct 2.6 states that a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Number 133, Comment 1 states that the right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Number 134, Comment 2 discusses the important role the judge plays in overseeing the settlement of disputes, indicating that the judge should be careful that efforts to further settlement of disputes do not undermine the party's right to be heard according to law, and that the judge should keep in mind the effect that the judge's participation in settling disputes may have, not only on the judge's own view of the case, but also on the perceptions of the lawyers and the parties in the case remains with the judge after set efforts are unsuccessful. The a judge shall hear and decide matters assigned to the judge except when disqualification is required by Rule 2.11 or other law. Comment 1 states that judges must be available to decide the matters that come before the court. The defense incorporates paragraphs 1 through 34 in support of Judge Gull's violation of the ICJC 25, 26, and 27. All right. 135, Judge Gull has held only 2 hearings with current defense counsel since June 15th, and one half of the March 18th hearing pertained to the prosecution's hearing on contempt, unrelated to the merits of the case. So there was really only 1.5 hearings, and that half was only because of something else. So 136, even though the defense has filed several motions seeking hearings on discovery matters that are deeply impacting the defense, Judge Gull has ignored the opportunity to assist in the resolution of those matters either through a hearing or some other means. 137, Judge Gull's refusal to act on discovery disputes raised by Richard Allen raises a rational inference of bias. Judge Gull has only allowed cameras in the courtroom once at the hearing when she knew one way or another that she was kicking attorneys Rosie and Baldwin off the case. Rule 2.8b states that a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's direction and control. Number 139, the defense incorporates paragraphs 1 through 38 in support of its contention that Judge Gull has violated ICJC 2.8. 140, Judge Gull has run one of the test courts for cameras in the courtroom and appears supportive of cameras in the courtroom. However, the only time in this case that Judge Gull has specifically allowed cameras in the courtroom was on October 19th last year. On that date, Judge Gull knew going into that hearing that she would either allow attorneys Baldwin and Rosie the opportunity to withdraw or proceed to the hearing in which she would read into the record a handwritten document that she penned before the in-chambers hearing disparaging and discrediting attorneys Baldwin and Rosie. This woman is evil. 142, Judge Gull's attempt to disparage the defense counsel with cameras in the courtroom, again, the only time the cameras have ever been in the courtroom, violates ICJC 2.8 in addition to all other facts pled herein. 143. It would be difficult to believe that an objectively reasonable person would not believe that Judge Gull has demonstrated bias and prejudice against the defense. Her own words, grossly negligent, incompetent, and sloppy, are proof of those obvious facts. Beyond Judge Gull's words lie her actions. They are articulated throughout the body of this motion. Actions often do speak louder than words. The actions of Judge Gull warrant her recusal and or disqualification. Number 114, the defense is requesting the court to restore public confidence by withdrawing from this case. The defense is requesting this court to disqualify itself to reduce the likelihood of costly appellate litigation and the cost of a retrial should a negative outcome against Richard Allen result from the trial should she remain on the case. It's a huge appellant issue, huge if she stays on the case. 145. The cumulative effect of each piece of bias and prejudice recited herein supports the defense request for a change of judge. Richard Allen, a man presumed innocent, deserves a fair trial, as do the victims' families and the entire Delphi community. Judge Gull's continued involvement in this case will leave a cloud of doubt over the legitimacy of the proceedings. And that right there is a key sentence. Judge Gull's continued involvement in this case will leave a cloud of doubt over the legitimacy of the proceedings. And it's just the truth. She has shown so much bias in this, and there's no redemption. There's no coming back. She needs to go, like permanently from off the bench. 146. Accompanying this motion is the affidavit of Richard Allen, which the defense requests to be incorporated into this document. We read the affidavit of Richard Allen in part one. So if you missed that, we read it right at the beginning. Right, the same affidavit sets forth the facts establishing the timeliness of defendant Allen's request for a change of judge pursuant to RCP 24C2. And finally, this motion is also accompanied by a certification that Richard Allen's attorneys believe in good faith the facts recited in the affidavit are true and accurate. Wherefore, the defense requests the Judge Gull recuse herself and for that other just and proper relief in the premises, for all other just and proper relief. And I swear and affirm under the penalties of perjury that the foregoing representations are true. So Richard Allen signed both lines there, and then certification by Bradley Rosie and Andrew Baldwin. So that is that. And now, ladies and gentlemen, we have a judgment in this case because of all of these filings that have been going on. This just came out today. Today, as in, what is today? Monday, the 20th. The order or judgment of the court. The court has reviewed the defense's second verified motion to disqualify judge and requests for findings of fact and conclusion of law upon denial of this request if the court denies this request, filed Friday, May 17th at 3:04 p.m. As the court is now required to review and rule upon the 42-page pleading, the court is compelled to cancel the pretrial hearing previously set with counsel's agreement. And that is, they wanted that. They wanted all proceedings stayed until they were able to deal with this disqualification because she needs to be gone. And that's how it works. Like once this motion is in, like she can't rule on anything else. So the court therefore orders the hearing set May 21st through the 23rd on defendant's motion to vacate. Okay, so they were going over a bunch of motions. I'm not going to read them all. Okay, I will. All right, so on defendant's motion to vacate safekeeping order, we read that. The defendant's motion to compel and motion for sanctions on Nick McLeland, we read that. The state's motion in limine, that was their filing stating basically we don't want any kind of third party culprit or odinous talk or anything in the trial. So they're basically preventing any kind of defense for the defendant. And the defendant's motion to suppress their second statement and the first statement, also the state's objection to the defendant's motion to suppress. So all of those were supposed to be gone. They were going to go over on the hearings for May 23rd through the 23rd. Why did they have 3 days, though, set aside for it? I guess maybe if they just needed that much to argue, but that's a long time. I don't know. I wonder if there was like something else brewing with Judge Gull as to a 3-day hearing with these guys. I don't know. Anyways, so she has canceled over the state's objection. The state has objected to canceling this May 21st through 23rd hearing. However, she has to. She has to cancel it, whether they object or not. So the transport that they arranged for Richard Allen to come to the hearings has been vacated. So they canceled that. Court is to notify, I guess, the transport or what? I don't know. Court to notify, whatever that means. So yeah, so they were supposed to have a hearing this week. That's canceled now. Thank goodness, because they weren't ready to argue that when they're trying to get rid of Gull completely anyways. I mean, get her off the case and then they don't have to argue half of these things. Um, anyways, so what do you guys think? Do you think she's going to recuse herself or disqualify herself, however, whatever term you want to say? I don't think she will, but this is such a strongly written document and there's no real reason for her. I mean, they have 146 reasons why Judge Gull should recuse herself. It went from 18 to 146. That's how badly she's botched this case, and that's how badly they want her off. Because every time they try to do anything, here comes some kind of obstacle that Gull is putting in your way. So they really do need her off. I think she needs to just retire from the bench completely. She's done, in my opinion. I wouldn't think if I was being told, "Hey, you're going up again," I'm a defendant and you're going to be in Gull's courtroom, I would say absolutely not. She's biased and I want her recused after I've seen everything that she's done with this case. I wouldn't, I mean, thank goodness I'm not in Indiana, but still, I would not want anything to do with her in a courtroom or outside of a courtroom. She just doesn't seem like a very pleasant person, in my opinion, the way that she's handled these things. And I don't think there's any redemption for how she's handled or treated Richard Allen and his attorneys. So that's my opinion, and I'm entitled to it. You guys are entitled to yours. Let me know in the comments below what your opinion is on Judge Gull. And thank you so much for watching. And don't forget to hit the like button on the way out. I will see you guys later. Take care. Have a good one.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.